Hello viewers, I am Dr. Sharmila Guge. Today we will discuss about the history of legal profession in our country. Objectives of the modules. The main objectives of the module are to learn about the history of legal profession in India, to strengthen knowledge pertaining to the historical legal events of India. Now let us begin with the introduction. The legal profession is an important branch of administration of justice in the country. An equipped and organized legal profession enables to administer effective justice. The pre-constitutional legal framework has passed through various phases to shape the present legal profession. Presently, the legal profession in India is a cornerstone of our society, playing a crucial role in upholding democratic ideals and facilitating the realization of our people's aspirations. The roots of the legal system can be traced back to the ancient, medieval and British India. Over the time, the framework of legal institutions, including the Bar Council and courts, took shape in accordance of the social progress. Notable milestones include the establishment of the Court of Judicature in Bombay, the formation of Supreme Court and High Courts, the creation of bar committees in 1926 and 1951 and the passage of the Advocates Act in 1961. Well, let us have a look at the ancient phase, the legal profession in ancient India. In India's history, the concept of law and justice has ancient origins. Legal principles were codified as exemplified in the Manusmriti. Ancient India had a sophisticated judicial system with the king as the ultimate source of justice, but no specialized legal professionals akin to the modern lawyers. In ancient times, the king was advised by his advisors in the royal courts. It was believed that dharma was upheld by the king, who followed the path of customs and righteousness in delivering the justice. Though royal courts lacked bar association, a few learned ministers of the king assisted in ensuring justice. Let us take a look at the medieval legal profession in India. So, the medieval legal profession in India, during the medieval period, India witnessed several changes with the advent of Muslim rule. There was the existence of legal profession as the party of the litigation appoints their vakils. However, this period the legal profession was not so organized. The vakils performed their work as an agent for the principal but not as lawyers. Then let us take a glance at the British India. How was the legal profession in British India? The contemporary legal profession and the court system in India owe their foundation to the legal structure introduced by the British colonial rulers. The lawyers today hold a respected position, empowering individuals to assert and protect their rights. A well-established legal system is integral to upholding the rule of law, and the India's legal system has matured over many years. Let us now discuss the evolution of legal system. The genesis of the judicial systems can be traced back to the presidencies of Madras, Bombay and Calcutta. Well, prior to 1726, these regions harbored diverse court structures. However, a pivotal transformation occurred with the issuance of the Charter of 1726, which standardized the court system across the three presidencies. And the inception of the legal profession in India can be pinpointed to the establishment of the Court of Judicature at Bombay in 1672. To name George Wilcox, chosen as the first Attorney General by the governor at that time, played a crucial role in enabling legal representation for individuals at a cost of just over 1 rupee. The robust judicial system in Bombay owed much to its development to the dedication and endeavours of Governor Gerald Oingier. He made an appeal to the company to send a legally trained juniors advocate, albeit met with the reluctance. This suggests that as early as 1674, India witnessed the presence of practicing attorneys, their admission being under the purview of the governor rather than the court. Notably, the charter and regulations of the mayor's court made no mention of the legal profession. These early lawyers lacked the formal training, and the clerical staff of the court simultaneously operated as practicing attorneys and businessmen. The first individual with legal training to be a part of Indian judicial system was St. John, appointed as a judge advocate for the Admiralty Court in Bombay in 1684. This court primarily dealt with maritime and mercantile disputes. The Kingwin Rebellion, however, led to the dissolution of the courts established in 1672, prompting the Admiralty Court to take on cases beyond its jurisdiction. So, friends, before 1726, neither Madras nor Calcutta harbored a legal profession with clearly defined rules, regulations or qualification requirements. This situation remained unaltered in subsequent charters. The establishment of Supreme Court at Calcutta marked a significant milestone in India's legal history, which was an outcome of the Regulating Act of 1773, and similar Supreme Courts were later established in the presidencies of Madras and Bombay. Well, the advent of Supreme Court assured in the presence of barristers in India for the first time. Barristers and attorneys evolved into the distinct legal professions, with barristers predominantly serving as advocates and attorneys, functioning as solicitors. Initially, barristers served as judges rather than practicing lawyers. The charter then established the Supreme Court, mandated that the Chief Justice and peasant judges must hold the title of barrister for 5 years term. The Supreme Court was vested with the authority to approve, admit and enroll attorneys as it deemed necessary. Attorneys on record were allowed to represent plaintiffs by appearing, pleading and acting on their behalf. The court retained the right to dismiss any advocate or lawyer for justifiable reasons, ensuring that only those authorized by the Supreme Court could argue or appear before it. The Supreme Court itself appointed 3 counsels: the Advocate General, the Company Counsel for Suits and Prosecutions and Company Counsels for Contracts and Conveyances. Other roles such as the Registrar, the Judicial Clerks of the judges were also held by lawyers. Progressing ahead, in 1774, Mr. Ferrar became the first barrister to practice as an advocate in Calcutta. His notable appearances as defence counsel for Raja Nandakumar in a controversial case where the judges took on a more prominent role in questioning instead of the Crown Counsel garnered significant attention. And to emphasize, this trial led to the impeachment of the first Chief Justice of the Supreme Court, Sir Elijah Impey, and then the Governor Warren Hastings in England. So, the legal profession in Calcutta, driven by high fees and a bargaining caseload, witnessed rapid growth in a short span. A similar trajectory was observed in the presidencies of Madras and Bombay, where 2 more Supreme Courts were established, mirroring the model in Calcutta. Notably, the Supreme Court did not accommodate Indian legal practitioners. Instead, advocates, barristers and solicitors in the Supreme Court operated within the framework of the British legal system, with English judges and lawyers exclusively presiding over the proceedings. The sole exception were the 4 Indian attorneys in Calcutta, along with Brahmin Pandits, Muslim Qazis and translators who served as assessors or legal officials in matters pertaining to Hindu and Muslim law. The legal profession evolved naturally without formal oversight, as the charters of these courts primarily emphasized the authority of the judiciary and qualifications. Let us take a glance at the Adalat system. So, the regions beyond the British presidencies referred to as Mufussil were under British governance, with the British authorities establishing a judicial system to administer justice in these areas. Warren Hastings introduced the Adalat system, which entailed the division of Mufussil into various districts. Each district had a collector responsible for both exercising judicial authority and tax collection. Within these districts, there were 2 types of courts: the Mufussil Nizamat Adalat for criminal cases and the Mufussil Diwani Adalat for civil cases. Appeals from these courts were directed to Sardar Nizamat Adalat and Sardar Diwani Adalat respectively. So, before 1793, Indian wakils and agents engaged in the legal practice without any formal regulation or recognition by the Diwani courts. The Naboobs, Zilla courts had wakils representing petitioners as early as 1772, although there were no established statutes governing their affiliation with the courts, eligibility, operating procedures or professional ethics. Later in 1793, the Bengal Regulation 7 was enacted in response to the need for regulated legal representation in the courts to ensure the administration of justice. This regulation stipulated that only individuals with solid educational background, high moral character, knowledge of Islamic or Hindu law and familiarity with English rules were permitted to appear before the Supreme Court. A unique aspect of this rule was its restriction to Hindus and Muslims for filing lawsuits, with preference given to graduates of the Hindu College of Banaras and the Mohammedan University of Calcutta. If suitable candidates were lacking from these institutions, the Sardar Diwani Adalat could select individuals of exceptional character and education. It was also mandated that a wakil appointed to one Adalat could not present pleas in another court without the consent of the Sardar Adalat. This provision was eventually modified in 1831 to allow members of any faith to practice. Subsequent regulations were introduced to further govern the legal profession, including the significant Legal Practitioners Act of 1846, which enabled the practitioners of the Supreme Court to practice in the Adalats. Now, let us proceed and check the establishment of the High Courts in India. In 1861, a charter was issued by the Crown enabling the creation of High Courts through the issuance of letters patents. The first High Court was established at Calcutta, with subsequent ones established at other presidencies. These High Courts were formed by merging the jurisdiction of the Supreme Court and Sardar Adalat. the High Court was vested with the authority to approve, admit and enroll such and so many advocates, vakils and attorneys as the said High Court shall deem fit. Those approved by the court were authorized to represent and act on behalf of suitors according to the High Court's rules and directions. Well, the High Court's regulations defined three types of legal professionals. 1. Advocates, 2. Attorneys, also known as solicitors, and 3. Vakils. A majority of advocates who typically English, Scottish or members of the bar faculty from Iceland. Vakils on the other hand were practitioners from India. Initially, only advocates were allowed to present and plead on the original side of the High Courts under the direction of attorneys. The distinction was rooted in the belief that High Courts, while exercising their ordinary original jurisdiction, succeeded the Supreme Court. Advocates were permitted to argue on the appellate side of the High Court and its lower courts, due to this notion that the appellate side had inherited the jurisdiction of the Sardar Adalats. Consequently, vakils were limited to arguing on the appellate side and not the original side of the court. Subsequent to the establishment of the High Courts in Madras, Bombay and Calcutta, additional High Courts were set up, although they did not pass original jurisdiction. Following the establishment of the High Courts, there were 6 distinct levels of legal practitioners in India, and to name them: advocates, attorneys also known as solicitors, vakils of High Court, pleaders, mukhtiars and revenue agents. So friends, the Legal Practitioners Act of 1879 unified these 6 professional categories under a single system that fell under the purview of the High Courts. Until the passage of the Advocates Act of 1961, these 2 pieces of legislation along with the latest patent of the High Courts governed attorneys in lower courts across the nation. Later on, the Indian Bar Committee of 1923, also known as the Chamir Committee, was formed by the government in response to the motion proposed by Munshi Ishwar Saran in the Legislative Assembly. The motion called the creation of an Indian bar to eliminate the distinction between barristers and vakils. This committee, comprising 4 barristers, 1 attorney and 1 civilian and 3 vakil bar members, were tasked with providing a comprehensive report on formation of the Indian bar, whether on all India or provincial basis, and the potential removal of differential treatment between barristers and vakils. The committee eventually concluded that creating all India level bar council was not feasible. So now let us proceed and see how did we have a bar council. Well, the Indian Bar Councils Act in 1926, this was enacted to put into effect the recommendations of the Chamir Committee. The Act's preamble clearly outlined its objectives. And what were the objectives? The objectives were to provide for the constitution and incorporation of bar councils for certain courts in British India, to confer powers and to impose duties on such bar councils, and to consolidate and attend the law governing legal practitioners entitled to practice in such courts. Well, the primary aim of this legislation was to standardize the various levels of legal practitioners and grant a degree of autonomy to the bars associated with different courts. Friends, it is worth noting that the Act did not extend to muktayars and pleaders in adalats. The non-barristers were permitted to plead in high courts, marking a significant change. To name, section 3 to 7 of the Act were dedicated to the establishment of a bar council as a body corporate, its incorporation and its authority to make bylaws. Well, the statute stipulated the formation of a bar council, commonly known as BC, for each high court with a total of 15 members. Among these members, 4 nominees for the position of Advocate General were to be appointed by the High Court, with a maximum of 2 of those nominees serving as judges. The remaining 10 members were to be selected by the High Court's attorneys. In the 3 main presidencies, the Advocate General was to serve as the Bar Council's ex officio chairman. The Bar Council was responsible for electing a chairman and the vice chairman. Prior to the Act, High Courts had the authority to enroll solicitors. Well, the role of Bar Council was advisory, and any regulation it enacted required the approval of the High Court to come into effect. High Courts retained the power to discipline advocates for professional misconduct. Now, let us take a glance at the legal profession in India after independence. So, friends, post independence, we had the All India Bar Committee in 1951. Prior to this, the Legal Bar Councils Act of 1926 fell short of uniting the Indian legal professionals and notably excluded the muktiyars, pleaders and other practicings in adalats from its scope. The councils created under this act lacked substantial autonomy, operating primarily as advisory bodies. The Act's achievements left much to be desired according to the Indian legal community, prompting sustained efforts to reform the system. The establishment of the Supreme Court in 1950 rekindled the demand for a national level bar council in India. And therefore, in response, the All India Bar Committee emerged in 1951, led by Judge S.R. Das. The committee advocated for the establishment of a single national bar, seeking to eliminate the distinctions among different levels of legal practitioners. Well, the central idea was to include all eligible lawyers on a single roll, thereby creating and maintaining a comprehensive list of advocates. The committee's report recommended the formation of state bar councils along with All India Bar Council. These councils were to be vested with the authority to enroll, suspend or remove the advocates. Furthermore, the report emphasized that advocates should be allowed to practice in all of the nation's courts, playing a uniform role. It also recommended that no additional non-graduated pleaders or muktiyars be appointed. Thus, friends, these suggestions echoed those made by the 5th Law Commission of India in its 14th report. And now, let us proceed to see how did we get the Advocates Act 1961 as it stands proudly today. Thanks to the findings of the All India Bar Committee 1961, significant changes ushered in by the government through the passage of the Advocates Act 1961, marking a transformative moment in the judicial system of India. The core purpose of this act was to uphold the dignity of all legal professionals in India, a goal eloquently stated in the preamble of the act. Well, the Advocates Act in 1961 enacted by the Parliament played a pivotal role in establishing the State Bar Council and the Bar Council of India as national entities in 1961. This legislation effectively replaced both the Legal Practitioners Act and the Indian Bar Council Act of 1926. The All India Bar Council formed under this act was entrusted with several crucial responsibilities, including number 1, setting guidelines for the professional conduct and demeanour of advocates in their practice. 2, safeguarding the interests, rights and privileges of advocates. 3, exercising comprehensive oversight and management over the state bar councils. 4, establishing standards for legal education in consultation with universities. 5, evaluating institutions and accrediting those that meet the criteria for conferring law degrees to individuals aspiring to become advocates. 6, promoting the study of law. 7, advocating for and felicitating legal reforms. 8, offering support and assistance in the legal field. Thus, going further, this statute also introduced state level disciplinary panel entrusted with the task of adjudicating allegations of professional misconduct, ensuring the ethical practice of law. There is a new amendment to the effect which has not been implemented, but let us make a mention, bring it to your kind knowledge. The draft of Legal Practitioners Act 2010. Well, the Ministry of Law and Justice, Government of India has unveiled in 2010 the draft Legal Practitioners Regulation and Maintenance of Standards in Profession, Protecting the Interest of Clients and Promoting the Rule of Law Act 2010, inviting suggestions from the public. But friends, the draft bill aims to provide for multifarious objectives in furtherance of enhancement of quality of legal profession in India. However, the same is still kept in abeyance and hence cannot be relied upon at this moment. Thus, to conclude this session, we may proceed and state the legal profession in India has been augmented post-independence and has triumphed in establishing itself as an imperative legal system in the world. Well, the legal history existing, the law profession has evolved over thousands of years, which has passed through the various stages of development and achieved a place of recognition. The role of government, judges, legal luminaries, etc. in shaping the legal profession has a lion's share in its development. The Bar Council of India and the state bar councils have added on to the growth of the legal profession. However, in the era of globalization, there is still a huge vacuum and the need for evolution and development of the profession. Thank you.